Why do the courts in the state of Idaho hate the First Amendment? I'll explain. A Delphi update. Somebody is playing games. Some interesting Alec Murdaugh news. Who's going to pay for that appeal? And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell so that you receive notifications when we go live or put up new content. And remember, you can always listen to us anytime on any of your favorite podcasting apps, including Apple and Spotify. And let's support the sponsor of today's show. That's right, CrimeTalkSearch.com. Go to CrimeTalkSearch.com. Sign up for that background subscription service today. You're going to be happy that you did. When you do that background search, a report is literally generated while you wait, and you're going to have information emailed to you in a report that's going to have all kinds of background history about the person that you are looking for. Sometimes it's going to be a little shocking what you find out. It's probably something they didn't tell you about. Anyway, go there. Remember, you can subscribe and you can cancel any time you desire. But while you have that subscription, you can do as many background searches as you want. People that are coming into your life, think about it. It is dating malpractice if you do not check them out. CrimeTalkSearch.com. All right, before we get started with the show, make sure you join us this evening, 6 p.m. Mountain Time. We will be going live for our show tonight, followed by our exclusive Patreon show immediately following our live show. So if you haven't become a Patreon, please join. And remember, on our Patreon show, you have the call-in line where you can call and we can talk about whatever you want, a case or anything. And of course, we'll do the Magic 8 Ball. That's right. A lot of questions we can ask the Magic 8 Ball this evening as well. All right. Let's go ahead and open the record for May 23rd, 2023. And let's begin with today's docket. First, why does the state of Idaho, or the courts anyway, hate the First Amendment? Why will they not allow news cameras to be in the courtroom? I do not understand. Yes, the court has to balance the public's right to know under the First Amendment and the defendant's right to a fair trial. But I think as we saw recently in the Lori Vallow matter, do you think it would make any difference whether cameras were in there the entire time or not? No. Do you think it would have made any difference if it wasn't all done in secret back in Judge Boyce's chambers? I don't think so. The fact of the matter is the truth and the facts are going to come out in court. What does it matter? As long as it's truthful, it is what it is. They're called facts. Well, anyway, jump into the Brian Kohberger matter. 30 news organizations have sought to appeal or change the gag orders that were issued back in February. And those efforts ultimately failed to eliminate the orders, but the news outlets will have another chance to make their case in a matter of weeks. A judge on Monday scheduled a June 9th court date to address the most recent motion to vacate the standing gag order. Now, an attorney representing the family of one of the victims, Kaylee Gonsalves, also filed a motion in opposition to the gag order. The Gonsalves family said in a statement Monday that at the same time, we are disappointed that the judicial process has not been more efficient in addressing the gag order. As you may recall, back in January, the Latah County Magistrate Judge Megan Marshall issued these, I think, overly broad, in violation of the Constitution gag order, barring attorneys, law enforcement agencies, and others associated with this case from talking or writing about it. Now, the news organizations have said the order violates the right to free speech. I totally agree. And yet the courts are allowing it to take place. Kind of troubling. It's what's even more troubling is, and maybe now that we have a district court judge handling the case, not a magistrate that handles county court proceedings, maybe somebody will take a little bit closer look at this matter. Now, not surprisingly, Mr. Kohberger and his attorneys, as well as the prosecution, have said they want to keep the gag order intact. And like I said, the court needs to balance the public's access to the information with the rights of all parties to make sure that everybody receives a fair trial. Now, the courts are going to try to control the flow of information around the case, I think, as we saw in the Lori Vallow matter. And frankly, it just doesn't work. Frankly, I think it creates more speculation than is necessary. Just let the facts come out. The only thing that matters is what is presented at trial and not in the court of public opinion. So, as we know, yesterday, Brian Kohberger chose not to enter a plea on any of the 5 counts that are filed against him in the most recently returned indictment. And he made the decision to stand silent, which is basically the way that the defendant tells the court, you enter a plea of not guilty for me, and then we'll schedule the trial. The trial is scheduled for 4 to 6 weeks, scheduled to commence October 2nd. Now, we got some other news. Now, everybody knows that Kaylee Goncalves, Madison Mogen, were among the 4 University of Idaho students brutally stabbed to death in their home on November 13th. Now, Xana Kernodle and her boyfriend, Ethan Chapin, were also killed that night. Well, the families of Goncalves and Mogen have filed a legal document to suggest that they are considering suing the city of Moscow for damages, according to this notice of intent to sue, dated May 3rd and 11th. Now, while no lawsuit has been filed, the claims would allow them to sue within 2 years. So remember, when you want to sue the government, remember, the government has sovereign immunity. You can't sue the king unless the king gives you permission to do so. And you have to give them notice under most states saying, well, we have to be put on notice if you're going to sue us. And so that's what these 2 families have done. And the notices don't specify what type of claim the family is making or the potential amount of money that they're asking for. And that's a little odd. So the attorneys for the family said this is a filing of a tort claim notice, and it's really just a safeguard. And it's a safeguard to protect the interests of the families, the victims, and really the whole community. Because if something goes wrong or was done improperly, then someone needs to be held accountable. And under the Idaho Tort Claims Act, the law creates liability for tort claims against governmental entities in Idaho if there's actually a claim. And it allows victims to bring claims against a section of the government. And the rules require that this notice of intent to sue be filed to put the government on notice. Now, the attorneys filing the claim said the notices also went to Washington State as well as the state of Idaho. And the attorneys filing those claims and notices say that they aren't meant to do anything other than to protect the interests of the families and the victims moving forward. Now, I get it. It's a tragedy. I get it. What are they going to say? The city didn't do their job? The state didn't do their job? I got a real problem with this. I mean, if the police were there and they said, hey, Mr. Kohberger, walk on inside, do what you want to do, I could see there could be a claim for that. But the police weren't there. What are they supposed to do? Predict the future? Pull out their magic 8-ball and say, ooh, we think a crime's going to be committed here tonight? No, they can't. So I get it. Family's grieving. They're upset. They want somebody held accountable. But the person they need to look to is Mr. Kohberger. Why don't they sue him right now for a wrongful death claim? The civil suit will be held in abeyance until the end of the criminal case. And there you go. Oh, but that's right. That's right. Brian Kohberger has no money. That's right. What do we say all the time here in Crime Talk? It's always about the money. And when they say it's not about the money, then you know it's absolutely about the money. I got a real problem with that civil suit. Hopefully nothing will come from it. I get the family. I'm sorry for their loss. I understand they're grieving. But there's only one person responsible, or whomever is responsible. Obviously, we'll give Brian Kohberger the presumption of innocence. But if they think he did it, go sue him civilly. There you go. Next on the docket, we have an update on the Delphi matter. Is somebody playing games? Well, remember the man who was investigated for some sort of potential role that he may have played in the Delphi murder investigation? Well, he was set to be sentenced in a separate case, but a continuance was granted for Keegan Klein as the defense sought to further review evidence and the potential to withdraw his plea. The next status hearing is being set for June 1st. But it also looks like the attorney is moving to withdraw. And you think, why would that take place? Well, King Klein was set to learn his fate after he pled guilty to 25 counts of child exploitation back in March. Specifically, he pled guilty to 25 counts for possession of images regarding children, soliciting children, and exploiting children. Yeah, not a guy you want watching the kids. But hey, in today's world, maybe you do. Maybe that's just insensitive. Or maybe it's okay if they watch somebody else's kids, not your own. I don't know. Anyway, Mr. Klein is a sicko, okay? He should not be around anyone under the age of 18. Frankly, he probably shouldn't be around anyone of the female gender. He is a creep. Look at this guy. He is every teenage girl's dream. What a heartthrob. Because remember, he was investigated, and his history showed that he was catfishing young girls to get explicit photos and videos from them, including Delphi victim Libby German, who was killed alongside her friend Abby Williams back in 2017. Now, obviously, this case gained more traction when a social media profile used to solicit photos from minors called Anthony Schatz was discovered and had interacted with Libby the night before she was murdered alongside Abby near the Deer Creek in Carroll County there in Indiana. Now, social media messages uncovered by investigators indicated that Libby thought she was to meet Anthony Schatz the next day by the Monon High Bridge. Investigators have never alleged that Klein was at the bridge that day or played an active role in the girl's deaths. And while Klein was never charged or named as a suspect in the Delphi killings, he has become inextricably linked to the case. Ladies and gentlemen, the guy likes young girls. I'm sure he likes even younger girls than what was in the Delphi case. Now the guy wants to play games, withdraw his plea. His attorney's withdrawing. He's playing games. He is a manipulator, a master manipulator. Hopefully the court will deny the request, and he will go to prison for the 25 counts to which he pled guilty to. Now remember, the attorney would basically have to say that he was ineffective if he wanted to withdraw his guilty plea and that he misadvised him of something. The attorney's not going to say that. And the court went through an extensive colloquy on the record. Are you sure this is what you want to do? You understand the rights you have, the rights you give up, and the possible penalties, Mr. Klein? Yes, I do. You were doing this of your own free will. Is anyone punishing you or threatening you to enter a plea of guilty? No. This is what you want to do? Yes. So he's playing games. All right. On to another game player. Little Murdaugh news. Alec Murdaugh, that is. You know, the guy serving multiple life sentences for the death of his wife and son. Well, a South Carolina judge in the civil case ruled that the convenience store operator Greg Parker will stand trial as a defendant with convicted killer Alec Murdaugh in the wrongful death trial of Mallory Beach. That trial is scheduled to begin August 14th down there in Hampton County. Now, Judge Hall, Daniel Hall, issued his order late Friday afternoon, and he rejected the Parker's bid for summary judgment, which is saying there's no question of fact that needs to be resolved. Judge, you just need to make a ruling. Well, most judges deny motions for summary judgment because there is a question of fact, and that's the job of the jury, fact finders in the case. So they denied the motion for summary judgment, which Mr. Parker and his convenience stores sought to be dismissed as a defendant. It was Mr. Parker's latest attempt that didn't quite work out so well for him in his attempt to be tried separately from Mr. Murdaugh or to be dismissed from the case in its entirety. Now, Judge Hall's decision apparently clears the final hurdle for the 4-year-old lawsuit to begin. Wheels of justice just churning away there. Now, the lawsuit was first filed back in March of 2019, a little more than a month after Miss Mallory Beach died in the pre-dawn boat crash in the morning of February 24th of 2019 in Archers Creek near Beaufort, South Carolina. The boat, it's alleged, was driven by a very intoxicated Paul Murdaugh, Alec Murdaugh's younger son. Now, Mallory Beach, was thrown from the boat and ultimately drowned. Her mother, Renee Beach, filed the suit in Hampton County, where both the Beach and the Murdaugh's family lived. That's called the appropriate venue. Now, Parker is the defendant in the lawsuit because a clerk at one of his convenience stores allegedly sold an underage Paul Then 19, some of the alcohol that Paul and his friends drank that night on the boat. None of the 6 people on the boat were of age to buy the alcohol at all, and Paul used his older brother Buster's driver's license to buy the alcohol. The stakes are a little higher for Parker. Why? Because it's all about the money. Under South Carolina law, any single defendant in a lawsuit with several defendants is responsible for paying all damages if the other defendants cannot pay. That's commonly known as joint and several. Multiple co-defendants, one has deep pockets, he has to pay, and then has to go and try collect from the people with no money. As we know, Mr. Murdaugh has no money. He's in prison, and he really has no assets now or probably in the future. So Parker could wind up, if found liable, being awarded damages, even though he may be less responsible in the big picture. Now, when we practice law, there's a portionality that comes in. So they said, okay, yes, somebody is at fault, but at what percentage of fault? Some people get 10%. Maybe Alec Murdaugh gets 50%. Mr. Parker gets 10%. Not that way in South Carolina. You're in for a penny, you're in for a pound. Anyway, the South Carolina Law Enforcement Division, also known as SLED, investigated the actions of Mr. Parker's clerk. And SLED was obviously charged with overseeing the alcohol violation and declined to prosecute the clerk, a lady by the name of Tehea Cohen. Now, Parker also contends that Paul was known to be reckless when he drank, and therefore his friends in the boat should have known better than to travel with him. It's called assumption of risk. I know it sounds kind of bad, doesn't it? You should have known the guy was a jerk. You should have known he was drunk, and you got on the boat anyway. You could have left. It's called assumption of risk, ladies and gentlemen. They were contributory negligent in the process themselves. And Murdaugh is a defendant in the lawsuit because he allegedly encouraged Paul to drink alcohol, and obviously he owned the boat. Now, the attorney, Mark Tinsley, who represents the Beach family, said that he wasn't surprised that the court rejected Mr. Parker's motion to dismiss and called it, well, frivolous, which is what most attorneys call the other side's motions anytime they're filed, well, frivolous. Anyway, the defense attorney for Parker and his company, Parker's Kitchen, said in the statement, while we believe summary judgment should have been granted, we remain confident a jury will use their common sense and find that Miss Cohen and Parker's are not responsible for the death of Mallory Beach. An attorney, a guy by the name of Dawes Cook Jr., an attorney for Alec Murdaugh, who is now serving 2 consecutive life sentences, as we mentioned, in the South Carolina Department of Corrections, said he would expect Mr. Murdaugh to attend the trial, but said he has no final decision has been made on that. Clearly, Mr. Dawes is an attorney paid for by the insurance company, and he's just going along for the ride on this one. Because let's face it, you could award $1 million against his client, $10 million, $50 million. It's not like his client's ever going to pay it. And just as a final note, as you may recall, at Murdaugh's trial, prosecutors asserted that the Tinsley lawsuit, in which he sought millions of dollars of damages from Mr. Murdaugh, helped expose Mr. Murdaugh's numerous financial crimes and millions of dollars in debts that he had. Obviously, once prosperous, now disbarred attorney, is alleged to have stolen at least $8 million from his law partners, family, and friends. But wait, we even have more Alec Murdaugh news. A South Carolina judge ruled late last Friday that attorneys for convicted killer Alec Murdaugh cannot use $160,000 in assets that are currently being held by receivers who have court-approved oversight of Mr. Alec Murdaugh's money. The $160,000 is needed to pay for legal fees and costs associated with the appeal to the higher courts related obviously to Mr. Murdaugh's convictions relating to the double murder of his wife, Maggie, and son, Paul. Well, Mr. Murdaugh's attorney, Jim Griffin, said at a hearing before Judge Daniel Hall in Lexington, after careful consideration, defendant Richard Alec Murdaugh's motion for payment of attorney's fees and costs are untainted funds is denied. Judge Hall wrote. Griffin told the judge May 3rd that the defendant Murdaugh and his 6-week trial had used up all of that $600,000 that the judge originally approved, and the defense attorneys needed an additional $160,000 to do the appeal. I mean, justice is expensive, ladies and gentlemen. Injustice costs a hell of a lot more. Who's going to pay for that? Well, the funds received from Murdaugh's retirement account in defense of the Murdaughs and the related charges at trial have been exhausted, Mr. Griffin wrote in his motion. And that's why they sought the additional $160,000. And Judge, obviously, Newman sentenced Murdoch to 2 consecutive life sentences for the 2021 murders of Maggie and Paul. Of course, Alec Murdoch has denied doing that in any way whatsoever. The $600,000 to finance Murdoch's trial defense came from the liquidation of Alec Murdoch's 401k retirement funds, and there's still an additional $424,000 in Murdoch retirement funds under the receiver's control. And hey, Mr. Griffin's only asking for $160,000. It's not like he's being greedy or anything. Mr. Griffin also stated that appeal costs are already mounting, and the trial transcripts alone have totaled $26,000. I'm telling you, ladies and gentlemen, justice is expensive. Now the court has denied the use of those funds from the Murdoch estate. I wonder how much longer Mr. Griffin will remain on the case. Somehow I'm hearing motion to withdraw rather prominently on a big motion. Nothing personal, Mr. Murdoch, but it's not like we're going to do it for free, right? All right, now on today's dumb criminal. This guy's dumb, ladies and gentlemen. So Florida police were called to the Palms of Clearwater. It's an apartment development late Sunday night with a witness reportedly seeing a man pulling his pants down and begin pleasuring himself to a video on his personal cell phone. Now, police identified the alleged pleasurer as Christopher Harris. This guy's 51 years old. Really? You don't know better? 51? Anyway, he was a resident at the Palms, which was described as a Mediterranean oasis, only minutes away from Clearwater beaches. Also, Mr. Harris connected the video to a Bluetooth speaker and began playing the video out loud as he pleasured himself. Multiple officers responded to 911, probably just to actually see if this was really taking place and laugh at Mr. Harris. And they did, in fact, observe Mr. Harris pleasuring himself by the pool. Now, after being advised of his rights, Harris reportedly admitted to playing with himself, adding that when intoxicated, he does some stupid things. Now, Harris was arrested for exposure of a sexual organ, which is a misdemeanor, and he was released from jail on his own recognizance. Now, just remember, ladies and gentlemen, if you're planning to pleasure yourself while watching adult entertainment on your phone while at your apartment complex outdoors, try not to connect your device to the Bluetooth speaker. You may draw a little more attention to yourself than you were actually looking for. All right, that's all we have for you today. Thanks for watching. Please join us tonight, 6 p.m. Mountain Time for our live. We'll see you then. Have a great day.